Changing the constitution is, of course, an important issue. In the United Kingdom, they just pass an act of parliament, which makes it so easy. But in the United States, there is a specified way in the Constitution for change, and that allows for change through two methods. One method is for 2/3 of the states to ask for a convention of the states. They go to Congress and they ask for a convention of the states. I understand it's never happened, but there are campaigns from time to time for a convention of the states. I know, for example, the great broadcaster, the well-known broadcaster, Mark Levin, is always proposing a convention of the states. The normal way is for Congress itself to initiate the amendment, and this requires a 2/3 vote in favour in both the Senate and the House of Representatives. And then that goes to the states. And there's a provision that a quite tight provision that 3/4 of the states, either the state legislatures or state conventions, have to approve this. So it requires a rather difficult process. And that's why there have been only 33 amendments in the United States, of which 10 were the first amendments, which were part of the Constitution. In Australia, when this came up, in the first conventions, something similar to the American approach was considered. That is, having conventions, having it start out in the Parliament and then go to the various conventions of the states. But by that time, by the time that the Constitution had reached a position of maturity, the idea of a referendum became dominant, because the Constitution itself was going to have to be approved by a referendum in each of the states. So the referendum came up in favour, the Swiss-style referendum, and in Australia there's provision for both houses to agree on a change in a bill. There's also a provision for one house to send a referendum to the people. An attempt to do this happened once. The Senate tried to initiate a referendum. It was passed in the Senate, but then when it went to the Governor-General to be sent to the people, the Governor-General was advised by the government of the day, who were opposed to the referendum, not to do this, so it expired. It's never been used in Australia. Every Australian referendum has been passed by, every question that's gone to a referendum has been passed by both houses. And as we all know from experience, that referendum, that proposal for change can only be initiated by the Commonwealth. The states have no role. And it then has to be approved by the people in a referendum nationally and in a majority of states. That is, 4 of the 6 states, if we still have 6 states, when a referendum comes up. The result is that America has had, as I say, 33 proposals for change, 27 of which have been passed. But when you take into account that 10 of those were at the time when the Constitution was really being approved, otherwise the states, a number of states would never have joined the Union of the 13 states without the first 10 amendments. If you discount them and say, well, there were only 17 approved, and in Australia only 8 approved, of the 44 which have been put to the people, the number which have been approved in Australia is roughly similar when you take into account the time. The Australian ones are all ones by the federal government. Most have been to increase the powers of the federal government. Most of those have been rejected. Some other ones have been to change some provision of the Constitution, for example, the requirement that the Senate be half the size of the House. That's been rejected. Australians are criticised by the politicians for not passing referendums. Why should they? Most of them have been to increase the powers of the federal parliament, and Australians haven't been happy about that. At the time of the referendum, the constitutional referendum, I was asked about there being a second referendum if the first were defeated. So I decided to look at the number of referendums which have been repeated, and I found that some questions have been put up to 5 times to the Australian people. But there is an experience in Australia, if the people say no once, they say no every other time. Every referendum which was defeated on the first occasion, whether it's been put twice, 3 times, or even up to 5 times, has been rejected. And then something struck me which I found absolutely appalling. Most of the referendums to increase Commonwealth powers, I found in 1999, would no longer be necessary because the High Court has handed over those powers effectively to the Commonwealth, which challenges, of course, the position of the High Court. Now, I would have thought, John, that the weakness in the American system is that the initiative is so much in the hands of the Congress rather than somehow spread. There is that provision for the Convention of States, but they've never got round to that, I suppose, because they require, what is it, 3/4 of the states, or two-thirds of the states, right?
No, 2/3 of the Congress to propose it to the states, and 3/4 of the states have to approve it.
Yes, but to have a convention of the states, which itself could initiate a constitutional change, you've got to get 2/3 of the states to ask the Congress for that.
Right.
And 2/3 of the states have never been able to agree on that.
Right.
Is it too difficult?
No, I don't think it is. I think it should be difficult. And the reason is, if you also look at Article 5 in the U.S. Constitution, spells out how it's changed, as you mentioned. There have been 37 that have been approved by the Congress and sent to the states, and 27 of those, or 33, right, and then 27 of those have passed. But there have been 11,000 that have been proposed to the Congress. So the numbers could be, astronomical. I don't know what that number is in Australia, but as you say, I think that the 44 that have been proposed and the 8 have been approved, it's a relatively similar percentage. But the other interesting thing that on the 27th Amendment, the final one that was passed, that was proposed 200 years before it was passed. That was to limit people in Congress from raising their own salaries while they're in session, in their jobs. And so I think those kinds of things, I actually personally like the Swiss model much better in terms of the referendums that can be proposed by citizens. Citizens can challenge laws. They can, with the proper number of signatures, they can get all of the propose a referendum to be voted on by the entire country. And it's very similar in California. In California, an enormous percentage of the budget is controlled by ballot measure. And there can be, as we've discussed before, a dozen ballot measures. Raise a tax on this, build a new school here, funds for this and for that. And specifically, the government of California was designed with a very weak executive, and much more along the Swiss lines, where it's much more direct democracy than the federal system in America is. So I think it should be difficult to change. I think it shouldn't be impossible, but I think that the drawback in America of not having a referendum is that you've got the federal government and the state governments deciding without necessarily the people deciding, which is why I like a referendum.
Well, why is it that the Swiss seem to be interested essentially in substantive issues, substantive legal issues, like immigration, for example? But in the United States, in California rather, it seems to be mainly very much budgetary measures seem to dominate.
Absolutely, they dominate.
Wonder why?
It's a good question. I don't know. I think that it's perhaps one aspect, one angle that you could argue that is that that immigration specifically is really a federal level. That's the laws are governed are federal, not at the state level. I mean, for example, with this COVID situation, the health crisis we're currently in, you had premiers closing their borders. I don't think that would be possible in America. And not just closing their borders to other states, but closing the borders to, say, neighboring countries, Canada or Mexico and so on. I just don't think that would, I don't think, maybe in a really difficult circumstance under martial law or something that could be declared, that would happen. But otherwise, I think that mostly, and maybe, so that's maybe part of it is the people of California feel that those kind of issues are to be left to the federal government. Another is that for most people, I think, an individual taxpayer, their main concerns are not how many people are coming across the border, is the death penalty allowed? They're like, how much is it going to cost me out of my pocket? So I think because of that is potentially why most of those ballot measures are finance related.
And you rightly point to the situation in Australia during the COVID crisis, when state governments closed their borders. Now, when that went to the High Court, there's a very clear provision in the Constitution that trade, commerce, and intercourse between the states shall be absolutely free. It's there in Section 92. And the courts have read into that an understanding, an implication that you can still control the borders in relation to health matters, disease and so on. You can, for example, as we know, there is some control over the movement of fruit across the frontiers or the borders of a state, moving into Queensland from New South Wales and so on. But it seems, I think it's reasonable to say that the borders were closed not purely for health reasons. I think it's fair to say, this is a judgment of mine, that they were closed quite often for electoral advantage, apparent electoral advantage in being seen as a strong premier. And the closures were often unreasonable. And the High Court showed little interest in getting involved in this. And I think you're absolutely right. I can't see this happening in the United States. The fact is that the United States is much more of a federation than Australia. When the founders were developing the Australian Federation, they did not want to follow the Canadian model. They saw it as tending towards centralisation, giving too much power to the centre. And they preferred the American model. The fact is that the Australian model, with all of the efforts of the founders, has become probably the most centralised of federations in the democratic world, certainly from the point of view of tax. About 80% of all tax is collected by the federal government, which gives the federal government an enormous power over the states, which was specifically guarded against in the American Constitution, because it means that the Commonwealth controls the purse, and the Commonwealth can tell the states what to do, and they give the states about half of what the Commonwealth receives, but then tell the states how to spend it. So you get too much centralisation in breach of what the founders established, what the people agreed to, and what the people have said in every referendum on giving more powers to Canberra. And I would say, purely as an observation, I would say that running things from Canberra rather than running things locally does not necessarily lead to good government.
Well, I think that, and we discussed this previously, that the first Constitution of the United States was the Articles of Confederation, written in 1777 after a number of drafts. Benjamin Franklin proposed one that was discarded, and then there were a number more drafts before that was, and it wasn't ratified for 3 more years until 1781. But because they were the 13 colonies that then became the 13 states, it was very state-centric. there was there was no executive. There was one legislative body, and each state had one vote. So there were 13 votes in that legislative body. But it was the states that taxed, and then, well, actually what happened when that Constitutional Convention was called in 1787, when this article was essentially ripped up and rewritten as the current Constitution, was because there was an uprising around tax, of course. Farmers were being taxed or something, and somewhere in I don't remember, something rebellion.
Shays Rebellion.
Yes, I think you're right. And I think that was in 1786. And the federal government had no power, almost no power, and no military, and no way to tax. So that's why they said, this is it. This just isn't going to work. We can't fix this. We have to start from scratch and rewrite it. So, but I think the point is that because of those beginnings 250 some years ago, those powers of taxation and a lot of powers are left to the states rather than the federal level. So
I think we're agreed then, are we? Not that there should be initiatives by the people.
I think so, absolutely.
This was a mistake, I think, in both treaties, in both of the constitutional systems. There wasn't sufficient regard to the people. We did regard the people in relation to the referendum, but I don't think the founders foresaw how concentrated the power would be in Canberra. It's extraordinary that they didn't see that, because similar things had happened to an extent in the United States. We discussed this earlier in relation to the High Court. The founders would have been aware of some of the terrible decisions taken by the Supreme Court, particularly the Dred Scott decision upholding slavery, which some say triggered the Civil War. Now, it seems extraordinary that they didn't decide then that perhaps the High Court, if it's to be the final court, that was their intention, although the British insisted on keeping the Privy Council. If we were to have such a powerful High Court, that it should have been chosen in a different way than just the government of the day in Canberra, where you tended to get centralist judges rather than judges from the states.
Yes, I agree. I think on the flip side of that, I think that in writing the Australian Constitution, the founders of Australia took into consideration the evolution of the document in the U.S. Constitution and the Bill of Rights. It's too bad we don't have a Bill of Rights. I don't know why they didn't get to that part. Maybe we will one day, because I think that there are things, such as free speech, for example, that they're not codified anywhere. But I think that back to your judicial decisions that were being looked at, there's one, and you'll know the name of it. It's in regards to judicial review. And it's an American decision. Marbury and Madison, exactly. And that essentially said that the judiciary can overturn laws that have been passed by the Congress if they find them to be illegal. And it's a significant decision. And the founders of Australia decided to include that provision as part of the Australian Constitution.
And the American founders didn't intend for that power to be held by the Supreme Court.
That was an interpretation, exactly.
They intended that the Supreme Court be something like the Judicial Committee of the House of Lords, that it would be the final court of appeal only on federal matters, not state matters, unlike our High Court. Our High Court, one of the improvements the founders made in Australia was to make our High Court a general court of appeal. And you can see that, for example, in the Pell case. The Pell case in America would stay with the Victorian Supreme Court. It couldn't go to the Supreme Court because it was essentially a state matter. It wasn't a federal law. Whereas in Australia, the High Court is a general court of appeal and can deal with this, and they saw this as a great advantage.
I looked into that recently just because of the Texas decision we were talking about a moment ago, with the state of Texas suing the 4 other states that they didn't agree with the election provisions and so on of this recent 2020 election. And there's a very, I didn't realize before I looked it up that a state or anyone could go directly to the Supreme Court to file any kind of a case. I thought it had to go up through the appellate courts and the lower level courts in order to get there. But there's a very narrow provision in the American Constitution that says that they can sit for those cases, but mostly around land and around water rights and those kinds of things that would be a federal issue.
And states can go nowhere else if they want to sue another state. There's no other court they can go to. The state of Texas couldn't have gone to the Pennsylvania Supreme Court because it would not have got justice there, being an elected court in particular. Yeah. No. Good. Well, I think we might conclude with our consensus that there should be a right of initiative in the people of Australia.
Absolutely. And I would think that even a step further than that, to go to closer to the Swiss model that you mentioned frequently, I think is even more democratic than what we have.
So initiatives by the states, perhaps a number of states, you could have, for example, an initiative by 2 or 3 states, not just one, or an initiative by a certain number of Australian people, or a percentage of the electorate, or you might have to spread it across a number of states, but this would be a very democratic way of doing it. In Switzerland, it's just a certain number of people. I think it's 50,000.
It's 5% of the last number of people who voted in the previous election. So currently, I think it's about 950,000 that have to sign to make that proposal.
Yes. There is a criticism of this in Australia. It said that this would be time-consuming. People wouldn't like to have to go and vote regularly. Well, they vote regularly because we have compulsory voting. They don't have it in most other countries. The Swiss are quite used every quarter, every 3 months. There are not only federal referendums, there are state or cantonal referendums and local referendums. The Swiss are quite used to this.
But they have a very low turnout as well. They don't have a turnout much different than America. They, as you say, about 4 elections a year, but they have about 50% in a hotly contested election. I don't know what it was in the most recent American election, but it generally, for the elections between the presidential elections, it's 20 or 30%, and it can be 50.
Yes.
But I think, what about incentivizing people to vote rather than fining them if they don't vote?
You mean giving them money?
Or Christmas ham or something. some kind of an incentive.
Yes.
I don't know.
When you refer to the high level of voting in some parts of the United States, in some states or constituents, in some electorates, there were more than 100% of the people voting.
More than 100%.
Some suggested some of those votes were from the grave.
William Barr said he looked into it and he didn't find any misdeeds that would have changed the results of the election. And he was a Trump appointee, and it was, because he's stepping down, of course, as you know, and was very much, throughout his career, I read some interesting things about him, very pro-executive power. And he was, so he thought that the executive branch should maybe not be authoritarian, but it should have a lot more power and a lot fewer checks on its power than it does. And so for him to say, we didn't find anything that, any fraud that would have substantially changed the election, how do you argue with that? I mean, not that this is a question about that you've got it on the U.S. Constitution, but... Yes.
What do you think of counting in the absence and the sending away of what we call scrutineers?
I don't know the specifics of that, but I've seen you write on that very subject, and obviously that sounds like somebody's up to some misdeeds.
It wouldn't be because of the virus or because they had bad breath or some other matter.
I don't know the details on that. If that actually happened and there were people sent away that were supposed to be observing, then that should be looked at. It should be investigated. Absolutely.
And when we talk about an initiative, that is the people having an initiative, obviously, you'd have to make sure that the electoral rolls were up to date and valid. And this is one of the weaknesses. There's a committee of the Federal Parliament which is looking at this at the moment. They do come out with recommendations, and I think one of the recommendations is it's far too easy to register in Australia. To register in Australia, all you need do is fill out a form, post it in, and it has to be signed in front of a person who purports to be an elector. And that seems a little loose, I would think.
Also, and you've pointed this out in our discussions previously, is you can go to a lot of different places, and maybe you're checked off in one, but that doesn't mean you couldn't go and vote in another polling place. Which, and coming from a technology background, I don't want to get into too much detail on electronic voting, but there's technologies now like the blockchain, which is going to be used for contracts, smart contracts. And there's no reason that we couldn't vote using a blockchain-based system. And if you look at little Estonia, for example, Estonia's got 1.3 million people up there in the northern part of Europe. And what they've done is they've digitized almost every government service. So you vote online, you pay your taxes, you can get your, whatever services you need. You can do it electronically, and you've got a card, and maybe you've got a little card reader, or I'm not sure, a thumbprint. I'm not sure exactly how they do it, and it seems to work fine. But I don't know why we can't seem to get this right. But as you know, here, and I know this is one of your questions. Maybe I'm jumping ahead, but it's managed at the federal level. In America, it's state by state and county by county. They're all using different machines and paper ballots and electronics with paper backups and some and all these different things. And there's so many things that can go wrong. And it seems like it's not quite pulling the old lever, but it seems kind of like that.
Indeed. So on that point, I think we will come to a conclusion on this. We're both in favour of initiatives.